Hello, my name is Michael Tesoro, and I've prepared this video case note entitled Not Just a Rubber Stamp, ACCC and Uber BV. And the reason I've called it Not Just a Rubber Stamp is because I think it represents the federal court reacting against the conduct of not just the ACCC but other regulators coming to them with agreed penalties which don't have any of the evidence that is needed to explain how the agreed penalty was arrived at and how the relevant mandatory factors have been taken into consideration. This conduct's been going on for quite a while now, and finally a federal court judge has put down his foot and said no longer. A bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to Sarah Lou Consulting for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a director of enforcement. Outline the presentation, start with the background facts, then look at the criticism by Justice O'Brien of the parties, primarily the ACCC. Also, then look at the decision of Justice O'Brien, and then finish with the implications of the case. Now, there were two representations. The first was the Uber taxi representation, and this was representation made between June 2018 and August 2020. And effectively, Uber would display this message on its app and on the website, which estimated the fare range for a particular service, the Uber taxi trips. And this was a service that was only offered in Sydney. And they would represent to customers on the app and the website that a trip using Uber taxi would cost a certain amount of money. The problem was that the actual price paid by the rider or the passenger was in most cases less than the estimate. So in 90% of cases, the estimate would be higher than the actual fare that the customer paid, which is sort of an unusual misrepresentation. You'd ordinarily assume the reverse, that a company might be telling consumers the service is actually cheaper than it is to encourage them to use the service. The second representation is called the cancellation representation. This is conduct that occurred between December 2017 and September 2021. And this was a display message that came up again on the app and the website in relation to consumers who are using particular services, so UberX, Uber Premier, Uber Comfort, or Uber Pool Ride. And effectively, this would tell customers who had clicked on the button on the app or the website to cancel their trip that under Uber's terms and conditions, they may be charged a small fee if they went ahead with their cancellation. Now, the situation was that under the terms and conditions that applied to those particular customers, they would not be charged a cancellation fee if they went ahead and cancelled the ride, and none of these customers were actually charged a cancellation fee. So I guess the concern there is that by telling customers that they might be charged a cancellation fee, it could be seen as seeking to deter those customers from cancelling their ride. Now, this was settled by ACCC and Uber, and they agreed on a statement of agreed facts, which was filed with the court, as well as some joint submissions on relief. Now, the case involved agreement on a range of remedies, including declarations of breaches of the Australian consumer law, which Uber agreed to that, admitting contraventions, the payment of a total pecuniary penalty of $26 million, $8 million for the Uber taxi representation, and $18 million for the cancellation representation, injunctions, publication of corrective notice on its website, establishment of an Australian consumer law compliance program, and a contribution of $200,000 to the ACCC costs. Now, this settlement went to Justice O'Brien, and he was very impressed with what was provided to him. He said that this was a very large fine, very substantial fine, and where there's such a substantial fine being proposed, and the court's been asked to review it, that there has to be significant evidence filed to support that fine. And he believed the evidence was grossly inadequate, and the evidence did not adequately explain how the figures of $26 million had been arrived at. So he was very unhappy. There was further criticism that the information provided had no information about the value of the commerce affected, no evidence about the value of the financial harm suffered by consumers or by other persons, and other persons may be taxi drivers. So here's some relevant statutory factors which the court has to take into consideration: the level of harm to consumers, and there's no evidence before the court on those issues. Some further criticisms of the material put to the judge: the evidence provided no information as to the potential for financial gain to Uber, and the form of the evidence was also disappointing for the judge. He thought the evidence took the form of conclusory statements which were expressed at a high level of generality. So it wasn't specific evidence saying that particular individuals had knowledge of certain things and there was particular benefits arising from the contraventions. It was all very general. So the judge was very unhappy, as you can gather by those statements, and he decided that prior to the hearing of the matter that the parties file additional evidence, and he asked for further evidence submissions on 2 points. Firstly, the nature, extent and quantification of any loss suffered by any person as a result of the contraventions, which is a mandatory statutory factor which the court has to consider, so that's a fairly reasonable request. And secondly, the profit earned by Uber from having breached the law. And that evidence was filed in the proceedings, and Justice O'Brien reviewed it, and he concluded at paragraph 22 that additional evidence was underwhelming. So he stated at the hearing on the 25th of July that he didn't consider that the evidence before the court supported the quantum of penalties that they were proposing. And I remember they got quite a lot of publicity in the media, and the judge saying that these amounts just don't seem to be made out based on the evidence. So he looked at the various evidence that was provided, and he made this observation in relation to the Uber taxi representation that there was no evidence to attempt to quantify the extent of the overestimation of the likely fare. So here, consumers are being told that the fare is going to be a certain amount, and there's no evidence to say whether the overestimation was $20 or $1. And that's a very significant consideration, obviously. If the overestimation is a little amount, it's not going to have a big impact on consumers, but if it's a large amount, it's going to impact their decisions. Also, he looked at the suppression of demand. He's trying to work out if there's other forms of detriment which need to be looked at. So would these representations suppress demand for taxi services and result in more people using other Uber services? And there was no evidence to quantify the likely consequences for consumers, Uber or taxi drivers from this suppression of demand. In relation to cancellation representation, he was also critical that there was really no evidence before him that explained the quantum of the cancellation fee which was being charged. So was it a few cents, or was it a few dollars? So that wasn't spelled out. Also, there was no evidence about the cost to the consumer or the gain to Uber. So it's not explaining how much customers are being charged for cancelling their fee, or how much they thought they were being charged, nor if there was any financial benefit to Uber from customers deciding not to go through with their cancellation. Some further criticism there, that he asked for additional evidence to be filed in the court, and he noted that it took the parties a number of weeks, or actually he said many weeks, to compile this further evidence. And that led him to infer that if it was taking them many weeks to assemble this evidence, that they mustn't have, the ACCC must not have sought this evidence at an earlier time, which seemed concerning, because these are mandatory statutory factors which the ACCC has to be satisfied of, and they didn't have the evidence in their possession. So that lends, I guess, some credence to a suspicion that this number has simply been plucked out of thin air and isn't based on a consideration of the relevant mandatory factors set out under the Australian consumer law. So he looked at the representations and noted that in relation to the Uber taxi trips, it was a very small part of the business. So as I said earlier, it only related to Sydney, and it constituted less, or about 1% of total Uber ride shares in Sydney during the relevant period, but it actually dropped off even further. So obviously wasn't very popular. It dropped off in 2020 to around 0.1%. So it's a very small part of the business. Secondly, it was clear that the fare was overestimated in about 90% of the time, and given the number of customers who used the service, that meant that of the 128,000 customers who used the service and potentially being exposed to the overestimate of the fare, 114,000 customers had seen the representation. So effectively the Uber taxi representation was made to 114,000 consumers. With the cancellation representation, it was also very interesting that looking at simply the UberX, Uber Premier and Uber Comfort rides, there was 7.39 million trips where the customer had clicked on the cancel trip button. So that's how many times people had decided to cancel their trip, and that's when they would have seen the message saying that they're going to be charged a small fee. And it's interesting that even though 7.39 million people saw this warning to say they were going to be charged a small fee if they went ahead and cancelled their trip, only 27,000 or 0.4% of those customers changed their mind. So that's the thing. 7.39 million people want to cancel their trip, and the vast majority of those people are not being influenced in any way by the message that they're going to be charged a fee. They go ahead and they cancel their trip. Only 27,000 customers potentially decided to change their decision due to the fact they're going to be charged a small fee. Now that's assuming, because there might have been other reasons why they changed their mind. And when you look at the Uber Pool service, which is a much smaller service, as you can see, only 75,000, roughly 74,000 rides. As you can see, the cancelled trip was selected on 75,000 occasions, and only 332 customers decided to change their decision to cancel the trip, or 0.4%. So this message about charging consumers a fee for cancellation did not appear to have a very big impact on the decision making of consumers. So looking at the penalty calculation, as is required on the Macarian, the court has to consider what the maximum penalty is, because that's what the legislature has set out, and he did that looking at the cancellation representation. And as you can see, there are a large number of people who've seen the representation, and each time a person sees a representation, that's a separate breach. So he concluded there was 7.46 million contraventions of the Australian consumer law, and that would have been a penalty in excess of $100 trillion. Then when he did the same analysis in relation to the Uber taxi representation, obviously a lot less consumers had seen the representation, only 114,000. So once he did the multiplication on that, the amount only came out to several $trillion. So in both cases, ridiculously high maximum penalties. But as Macarian states, the court has to look at the maximum penalty, and also the penalty that's awarded or imposed by the court has to bear some relationship to the maximum penalty. What Justice O'Brien did is he relied on the decision in Reckitt Ben-Kaiser case, where it was found that if the penalty is so ridiculously high, it doesn't constitute a meaningful overall maximum penalty, the court is required to consider other approaches to working out the penalty. And one approach that the full court in Reckitt Ben-Kaiser chose was to look at the loss to consumers arising from the contraventions. Now, he looked at the agreed penalty of $8 million, and he concluded that the penalty proposed was simply too high. It greatly exceeded the amount which he considered appropriate, having regard to the mandatory statutory considerations. So he could not make that penalty because it was simply too high. Then when you look at the representations there, he seeks to work out another way of calculating the amount. And what he looked at, he said that one metric is to look at the number of people who saw the representation and to multiply that by an average fare of $25. And when you did that, you arrived at a number of about 2.8 million. So that was close enough to 3 million. And so he decided that that was an appropriate number, around $3 million for the Uber taxi representation. And he notes there that this penalty is many times the revenue and net income earned by Uber Australia in respect to the contravening conduct. So he's taken a different approach, but it really doesn't make any sense when you think about it, because that's not the damage suffered by the consumers. You don't have any evidence of what the consumers did by seeing this misrepresentation about the cost of the fare. So it's not looking at detriment, and it's also not looking at the amount of money which Uber makes. So he's, I guess, worked backwards, I think, from the amount of $3 million to work out some equation that gives him that amount. But really multiplying the number of people who saw the representation by his estimated average fare for an Uber ride of $25 doesn't really follow as a penalty amount. And when you look at the Uber taxi representations, there were a lot of factors, I guess, going for Uber, which meant there should be a lower penalty. So there was clearly no evidence of significant consumer loss or damage, or loss to any other third parties such as taxi drivers. The conduct was clearly not deliberate. It arose from inattention to the way their various computer programs and applications were working. There was no evidence of a benefit arising from the contravention. Uber had no history of breaching the Australian consumer law previously. Uber had immediately ceased the conduct of becoming aware of it, and they'd ceased the conduct going forward, and there'd been a very high level of cooperation. So a lot of factors, objective and subjective factors, going in favour of Uber. And on the negative side, I guess the fact they had no training on Australian consumer law, protection law, was a serious omission, and that obviously counted against them. And they had a significant revenue. As you can see, in 18, they had 935 million up to $1 billion in 2020. The profitability was a lot less, but clearly that's a large revenue for a company. So I guess the $3 million seems appropriate looking at these factors, but not on the basis of the calculation which Justice O'Brien adopted earlier. Now, with the cancellation representation, Justice O'Brien considered that it was within the appropriate range, although he believed it was at the higher end of the range, and therefore he was happy to award $18 million. And when you look at the factors there, clearly there's a lot of factors going against Uber. The four factors are obviously no previous contraventions, the conduct ceased and was not ongoing, and there was high level of cooperation. But there was many more contraventions, up to over 7 million contraventions. Conduct had gone on for 4 years. There'd been modest losses which he'd sort of calculated of around $700,000. There was some knowledge of senior managers in the business of the conduct, and they'd failed to fix it up until the ACCC came knocking. Again, no training in relation to Australian consumer protection laws, and finally the revenue factors. So I guess an $18 million penalty in that second matter seems appropriate given the number of objective and subjective factors which went against Uber. Now, just looking at the case, I think it's an important case, because I think there've been a lot of agreed settlements coming to the federal court, not just from the ACCC but also from ASIC, with numbers as agreed penalties which don't have any evidentiary support, or very little evidentiary support, and courts and judges have been really struggling to make sense of these amounts, asking parties to file additional evidence to just sort of do their statutory duty, which is to obviously look at the mandatory statutory factors and arrive at a penalty which has some relationship to the maximum and is appropriate in the circumstances in terms of achieving general and specific deterrence. Now, the courts have just said with Michael O'Brien in this case that they're not going to be treated like a rubber stamp. We're not going to just agree to your penalty. We're going to expect you to put on clear, coherent, compelling evidence to justify the number that you arrived at. And as I said, this conduct's been happening a while. There was a Samsung case where the number was very confusing. There's also the Google location data case, which really didn't make a lot of sense. First Slate roofing, which again, the judge had to arrive at a penalty that was agreed that didn't seem to make a lot of sense. So I think now the ACCC and other regulators have been warned that this type of conduct cannot continue, that they need to put on cogent evidence when they're coming with an agreed penalty. And really, when they're negotiating with a respondent about settling a case, they should approach it in a principled manner. They shouldn't be just sort of saying, how about 50 million and then negotiating down somewhere in between the high and the low number. Really, they should approach it on a principled basis, spelling out their reasons for the number, looking at the statutory mandatory factors and explaining it, and then having a dialogue with the other side. And then all that negotiation should be put forward to the court in the form of evidence and submissions. I personally think that the penalties here look too high because the conduct itself really doesn't seem that bad. Like, there were some mistakes made, it was clearly not deliberate, there was a level of inattention, and it's hard to see that consumers actually suffered any detriment whatsoever or that Uber made any profit. So the penalties of 21 million or 26 million just really look too high for this particular conduct, which doesn't appear to have caused any or significant consumer detriment and was really arising out of inattention rather than any intentional act. So I think the judge has sort of fired the warning shot over the bows of the regulators, and that's worthwhile. Ultimately, he could have simply rejected the whole settlement, and I think if the regulators don't improve their act, that's going to be happening in the future. So that's all I had. It was an interesting case, not so much on the actual contraventions, but on the big warning that the judge, the federal court at Michael O'Brien, has given to regulators to get their act together in terms of justifying the agreed penalties which they agree to or put to the court. So if you have any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.